If you're under investigation or facing criminal charges in Texas, you're probably wondering what happens next. What do court settings actually look like? How long does the process take? And what should you expect when you walk into that courtroom? Many people assume that once you're arrested, you'll quickly have your day in court where everything will be argued in front of a judge or jury. But the reality is very different. The Texas criminal process involves multiple stages, and in many cases, you may attend several court settings before your case reaches a resolution. Settings where you might not even speak other than confirming your presence. These stages are designed to ensure that both sides are actively working on the case, that defendants remain compliant with bond conditions, and that the courts stay on schedule. The process begins with the investigation. Whether it starts with a 911 call, an officer's observations, or a complaint filed against you, law enforcement will gather evidence, identify suspects, and determine whether there's probable cause for an arrest. If you're a suspect in a case, law enforcement may try to question you. This is where many people make a crucial mistake, speaking to the police without legal representation. Never give a statement to law enforcement without an attorney present. What you say can and will be used against you. If law enforcement believes there is enough evidence, they will present the case to a magistrate who will review the details and determine whether to issue a warrant for your arrest. If you're arrested, you'll go before a magistrate who will formally inform you of the charges against you in what's known as an arraignment. This is where the criminal process officially begins in the courtroom. The first setting in your case is usually the initial appearance. This is a critical stage because it ensures that you have legal representation and sets the stage for your bond conditions. If you've been released on bond, the court will reinforce certain restrictions that you must follow, like not committing any new offenses, checking in regularly with a pretrial officer, or even wearing a GPS monitor in certain cases. Violating these conditions can lead to serious consequences, including having your bond revoked and being taken into custody. If your case is a felony and hasn't been indicted yet, your attorney may request an examining trial. This is a process where the state must present enough evidence to show probable cause that a crime was committed. If they fail to meet this burden, the charges could be dismissed. However, in some cases, there may be strategic reasons for waiving this process. Once a felony case is indicted or a misdemeanor case is officially filed, your case enters a series of court settings. The first is the consultation setting, where your attorney will begin negotiations with the prosecutor. This is often when the prosecution extends a plea deal. Your attorney will review the state's evidence, discuss the offer with you, and help you decide whether to accept it or proceed to trial. If you do accept the plea, you'll sign a formal plea agreement and the case will move toward sentencing. If not, your case will proceed to further pretrial settings. The next step is the evidence exchange setting. By this point, the prosecution must provide all of the evidence they intend to use against you. Your defense team will examine everything: police reports, surveillance footage, forensic evidence, witness statements, anything that could impact the outcome of your case. At this stage, your attorney may also identify any issues with how evidence was obtained. If law enforcement violated your rights during a search or interrogation, your attorney may file a motion to suppress that evidence. This brings us to the motion setting, where the judge will hear legal arguments on whether certain evidence can be used at trial. If your attorney believes your constitutional rights were violated, they may file motions to suppress evidence or even dismiss the case entirely. The prosecution, on the other hand, may file motions to admit evidence or request certain legal rulings before trial. If these issues aren't resolved, the case moves to trial. In some courts, before trial, there is a status conference. This is another opportunity for negotiations. The prosecution may offer a final plea deal, and the court may encourage both sides to reach a resolution before trial. However, if no agreement is reached, the case moves forward. As the trial approaches, the announcement setting is held. Here, both sides confirm whether they are ready for trial. If you choose to move forward, you will go before a jury, 6 jurors for a misdemeanor, 12 for a felony, and present your case. For those facing state jail or third-degree felony charges in Texas, certain offenses are prioritized for expedited trials. These include burglary, fraud charges, theft, evading arrest in a vehicle, unauthorized use of a motor vehicle, and certain firearm offenses. If your charge falls into one of these categories, your case may move faster faster through the system. Trials are where everything comes to a head. This is your opportunity to fight the charges in front of a jury, challenge the state's evidence, and present your defense. The prosecution must prove guilt beyond a reasonable doubt, and your attorney will work to create reasonable doubt in the minds of the jurors. If you're found not guilty, your case is over. If you're convicted, sentencing will follow. The criminal process in Texas can be long, complex, and stressful, but you don't have to go through it alone. Having an experienced defense attorney on your side can make all the difference, protecting your rights, guiding you through the process, and fighting for the best possible outcome in your case. If you or a loved one are facing criminal charges in Texas, reach out to the experienced attorneys at Varghese Summersett. We understand the system, we know the stakes, and we will fight for you every step of the way. Search for Varghese Summersett on Google or call 817-203-2220 for a confidential consultation.